Hey everybody, Merry Christmas Eve. Hope everybody's having a good one, whether you're celebrating or just celebrating a regular Wednesday, a hump day. Hope everybody's doing well. We left off yesterday. That was a long motion reading. I was losing my voice. Wish I could read forever. This stream's going to be a little bit short so I can keep my voice together and also get some stuff done, prepare for holiday dinner tomorrow. So we're going to continue looking at the post-conviction relief motions, everything down the docket. Christy had grabbed a web archive and we were able to download all of the available filings after the site was pulled down yesterday. The web page was pulled down. So I'm going to add that to the description. It's also dropped in the chat if you want to follow along. And really the major thing we left off with was the judge denied the petition for writ of quorum nobis. So now we're just dealing with the petition for post-conviction relief, namely the relief sought new trial. And we are up to a motion to subpoena and depose and schedule depositions of subpoena lawyers and allow Zoom depositions. So this is filed by Doug Bates. He says he wants to subpoena and sit Michael Scholl, Michael Flanagan, ADA Paul Hagerman for depositions. And we're going to skip most of this motion. They're going to say what documents they want. We're going to scroll to see what specifically they're looking for. Alrighty. And hey to everybody in here. So Christy's here already. Good to see you, Christy, and thank you again. We've got everything is fine over here. It says Merry Christmas, chat and cat. Heck yeah. Hey to O'Bailey's, aka Factual Lie. Hey to Jersey Girl Trey, aka Trey Keisha. And hey Katie, good to see you. Melissa gets to join us live. That is awesome. Have a good trip. Have a good Target run and done. You're probably going at a good time. Better now than later. So good luck with your shopping trip. And hey Gigi. All right, so let's get a cursory view of what they're looking for. All right, so when it comes to Paul Hagerman, they're looking for written communications, anything including emails, letters, notes, text messages, or similar written communications through apps utilized by prisoners. So that would indicate they're looking to see if Paul Hagerman has communicated maybe with Jason Autry, maybe other witnesses. 2 negotiations in quotes. So they're defining this here. This means all discussions. So we're going to define this for you so you can't sit there and say, well, I wouldn't classify that as a negotiation. We're looking for all discussions with any agent of the state of Tennessee regarding any resolution of the applicable case beyond a trial on the merits. This includes all manner of consideration from both the state and the defense, and further includes each and every part of the case that could be resolved by the negotiation. So think back to what we heard in February of 2017. We're not going to need a trial date for Jason Autry. Well, that would imply there's some resolution being discussed, being negotiated, where the outcome would be something other than a trial. So that would be covered by what we're requesting here, those conversations. And we have to define the state, which is hilarious. Means any agent in any capacity of the state of Tennessee and their apparent agency or actual agency authority in the applicable case as the prosecuting or investigating party against an individual. So they want all these written communications you've had with anyone on behalf of Jason Autry, including former attorneys, co-counsel, family members, or other persons with whom you discussed Jason Autry's case on his behalf from April 13th, 2011 until the current regarding this case. All written communications you've had with other attorneys or private investigators regarding all criminal cases, both federal and state, in which Jason Autry was accused, investigated, and or prosecuted by either the state of Tennessee or the United States of America. So, any conversations you've had with Beth Boswell, who might have been prosecuting both. All written communications you had with any other attorney representing Jason Autry discussing any negotiation. And again, we've defined that up here. It's not what you want to classify as negotiation. It's any discussions with any agent of the state of Tennessee regarding any resolution that's something other than a trial. All written communications about negotiations, negotiated plea deal, or discussion of forthcoming possible testimony with Jason Autry. All documents created by you, in any form regarding all criminal cases, both federal and state, in which Jason Autry was accused, investigated, and or prosecuted by either the state of Tennessee or the United States of America. This does not include any matter of discovery received from the state of Tennessee or pleading or order that was part of any court file. At the plea of Jason Autry, Mr. Scholl used a phrase called, quote, formal offers regarding what you had just received a month prior to Mr. Autry's plea deal in 2020. To the extent not addressed above, all written documents and or communications of all, quote, informal offers or otherwise negotiations with the state of Tennessee that you have had since April 13th, 2011 with any attorney representing Mr. Jason Autry. So even though we've spelled out negotiations above, we're going to get nitty gritty and say, look, we specifically are asking you for conversations about informal. And then they want all discussions with any agent of the state of Tennessee or the government, federal government, since January 1st, 2022, regarding Zach Adams' writ of error coram nobis and or post-conviction relief. This specifically includes now Judge Jennifer Nichols. Oh, I would love to see any responsive documents to this part. What if it was just like, oh my God, are they really doing this? And then all discussions with any current or former agent of Jason Autry, Dylan Adams, or Zach Adams since January 1st, 2022, regarding Zach Adams' writ of error coram nobis and or post-conviction relief. This specifically includes now Judge Jennifer Nichols. For Michael Scholl, they wanted, a lot of it's probably going to be repetitious if they spell it out. So they're defining the same things. And here they're defining cases. So cases means any criminal prosecution, either from the state of Tennessee or U.S. government, in which Mr. Autry is a charged party or person of interest. They want all the written communications. Let's see if they name anybody besides Jason here. They repeat the formal and informal offers. Anyone with any agency. All discussions since the January 1st, 2022 writ of error coram nobis. All discussions with any current former agent of the co-defendants. All campaign contributions you or your law office or immediate family members have made to any campaign in which Jennifer Nichols was a candidate since April 13th, 2011. JenniferNicholsForJudge.com. Okay, and the next one we've got, let's see, Michael Flanagan. So same definitions. They want all written communications you've had with other attorneys, whether co-defendants, Jason Autry or the state, and other private investigators regarding State v. Jason Autry for his alleged kidnapping, murder, and rape of Holly Bobo from April 13th to the current. All written communications you've had with, like, anybody about tactic or strategy. So there we go. Very interesting to see what Doug was specifically looking for. And that was November 25th of 2024 that was filed. So that's where we are in the timeline. All right, next document up. I think it's, oh, this one's diagonal. This one's diagonal. So it's response to the motion for in-chambers meeting and motion for order. So the petitioner, Zach Adams, is responding to the state here. So counsel has no objection to an in-chambers meeting and reserves all objections raised in such meeting. Counsel has reviewed with the 3 attorneys involved and submits the following general response. Petitioner is unsure exactly the legal approach, as this is admittedly a unique proceeding. So Tennessee Superior Court rules, right? So maybe states that neither the rules of civil procedure nor rules of criminal procedure apply to these proceedings, except as specifically provided by these rules. All right, this is the Superior Court, right? No, Circuit Court. I don't know. This is important because counsel find only the following rules of discovery. So Section 6C7 states that upon review of the court's preliminary order, the state shall provide to petitioner discovery of all those items deemed discoverable under Rule 16, Tennessee Rules of Criminal Procedure, if relevant to the issues raised in the post-conviction petition, and shall provide any other disclosure required by the state or federal constitution. Section 7 says the state shall provide discovery in accordance with Section 6C7. 8C3 says each party shall have the right to subpoena witnesses for appearance at the evidentiary hearing. And it is an interesting question whether Rule 28 requires the defendant to comply with Rule 16b1. So, state's probably demanding some type of reciprocal discovery. I actually forget what their motion said. And then he says, in this case, though, it is an irrelevant question because counsel for petitioner never sought discovery from the state and instead relied on receiving the file from Jennifer Thompson. Oh, is this why Doug highlighted, I already have everything from Jennifer? Huh. So counsel is attaching 2013 F-156, a Tennessee Formal Board of Professional Responsibility Ethics opinion that states a lawyer is permitted, but not required, to make limited voluntary disclosure to the prosecution of information related to the representation of the former client outside the in-court proceeding without judicial supervision or approval. However indiscriminate, unlimited, nor carte blanche, it says claret blanche, carte blanche? Disclosure related to the former representation is not permitted. So with that in mind, it does appear that the Rule 28 allows the state to subpoena all three witnesses to the trial and may require them to bring to trial the documents they have at the time isolated to specific requests related to the petition. However, that is all the state can do. Turning to each attorney and their feedback provided to counsel, here is petitioner's position. So, Mr. Jim Simmons, they're going to talk about Simmons. Mr. Simmons is in the process of transferring his entire file to counsel's office. His response mimics Ms. Thompson's. Ms. Jennifer Thompson. Ms. Thompson has provided her entire file to current counsel. If Rule 16 of the Rules of Criminal Procedure apply, then counsel suggests that all such documents would be protected under Rule 16b2. And this is bolded. It says counsel is prepared to provide a copy of all documents it seeks introduced at trial pursuant to Rule 16b1. Counsel did offer, and the state was willing, to allow the state to come to its office and inspect everything in his office that belonged to Ms. Thompson. However, it appears that the dictates of Professional Ethics Option 2013 version F-156 bar this. Short of that, the court must rule what authority a subpoena can be issued to counsel, who is not a witness, to prepare these documents in accordance with the dictates ethical responsibility. Should it have to, then counsel is requesting a continuance of the underlying trial, as this will take a significant amount of time to gather and determine what documents are relevant for what grounds of relief, and what documents should be withheld and a privilege log possibly prepared. So I think what they're trying to protect is anything that might be in here as some type of work product that Jim and Jennifer are bringing over, and or avoid the time and effort of having to redact and sort through. Because, probably can't just trust the state to filter things. And then Mr. Jerry Gonzalez. Mr. Gonzalez remains subject to a subpoena and will appear at trial as ordered. And then here's a little paragraph about the talk with the prosecution. There is absolutely no authority to compel the three former attorneys to talk to the state of Tennessee prior to trial, nor is there any authority to require them to talk with counsel for a petitioner. So let's see what, this is the Board of Professional Responsibilities analysis. So that's attached there if you guys want to go read that. I want to see the order on this. This is all about the state wanting early interviews with people that they don't really have apparently the authority to force to sit for a deposition. And hey to everybody that's come in since the first few documents. Good morning, good morning, good morning. Merry Christmas Trial and Error Podcast. Hey, Oracle Cat. Hey, Destined to Be. Still thinking about Melissa here making her Christmas Eve Target run. Good luck, good luck. Yeah, in short, give us everything. Heck yeah. This is no place I'd rather spend my workday in the bushes. That's right. That is right. We should have put Christmas lights on the bushes. I miss that. Maybe if we watch something, I'll like sneak away to Canva and put some Christmas lights on the Viverito bush picture. We'll decorate. Good morning, good morning. I love this. I love Audrey's fake accent. Yeah, I was wondering. I saw your name as I scrolled up, and then when I clicked it to read your comment, it displayed a different name. It displayed your old one. But yeah, so Audrey's fake accent. Love the new name. Love the new name. I might have to upload The Air Was Thick with Animosity as a sound clip for the chat. Yeah, he definitely has it up for the camera. I agree, and that thing that he does with his serious face. Very, very serious face. Also, shout out to Santa Sheriff Chuck gifting 5 memberships. That's amazing. You guys can now, there's a new emoji in there. There's I think I called it TBI Cry because I wanted it to rhyme, but it's really Brent or Brett Booth, whichever you prefer. We don't have a Brett Booth here. Oh man, but yeah, I thought TBI Cry was a good name. So now that you've got a gifted membership, say thank you to Sheriff Chuck and make sure you use those channel emojis. And heck yeah, love it. Court TV's confirmed that they'll be there on the 29th and 30th to live stream. I love it. That means there will be a live feed. So, hey, it's me. Stacy is green and says thank you. Well, hey, right back at you, Stacy. Yeah, there we go. Trikisha's trying out the emoji. Just, I love it. I love it. I've still got to get the Jennifer Nichols one. I will. The one where she's like this. I just got to make it like make sense as a tiny emoji. All right, so they're asking for extra time to file something here, to file the second amended petition for post-conviction relief. Does this give us the edits? All right, so sometimes when a party asks for leave to file an amendment, the edits will be obvious. But it's not indicating. So let's see. Let's see if there's like a quick, here's what we want to add, because otherwise this might be a reread of what we first read, the first petition. All right. We're filing the following amended. This is all the procedural history. And I wasn't sure, I'm not sure if this is updated. So let's read this in full. It might be a repeat, but this is about the failure to find, develop, and otherwise introduce exculpatory evidence and or new evidence. And this is all about the exculpatory, the alibi stuff. So, and I have it really tiny. Mr. Zach Adams was with co-defendants, Mr. Shane Austin and Mr. Dylan Adams, withdrawing money from the drive-thru ATM at the Community South Bank, now CB&S Bank, in Parsons, Tennessee, at the time of the victim's abduction on April 13th, 2011, as pled in the original post-conviction petition. On October 18th, 2016, counsel for Mr. Adams issued a subpoena on the bank in question, and the bank responded that no ATM recordings could be located. The only documentation produced responsive to the subpoena were bank statements reflective of the date but with no timestamp. This bank statement did, however, confirm a $120 ATM withdrawal made that day from Shane Austin's bank account, in addition to purchases at every other stop corroborating Mr. Adams' alibi. And they're going to put that in the table below. Upon receipt of this information, counsel failed to make any further inquiry or effort to obtain, recover the video ATM footage evidence that could exonerate their client. Further, counsel for Mr. Adams neither introduced his testimony nor offered into evidence any of the bank records corroborating this alibi. Moreover, upon information and belief, the former security manager at Community South Bank, Mr. Jason Bauckham, had offered to provide security footage to the TBI years before issuance of the subpoena, depicting defendant Zach Adams backing Mr. Dylan Adams' 2006 Chevy Silverado pickup into the ATM drive-through, with Mr. Shane Austin sitting in the passenger seat, accessing the ATM to withdraw money during the time of the abduction. However, this footage was either never obtained by the TBI, or if it was, the same was never provided to the defense, or the nature of it was never understood by all involved. So, in bolded here, it says this is a standalone claim of actual innocence pursuant to Dellinger v. State that has not been litigated in a prior proceeding because it was not introduced at trial. So I think this is an important addition here. B, that Zach Adams was on his grandmother's computer during the operative time frame on April 13th, 2011. This was pled in the original post-conviction petition. However, the petitioner requests this court consider this fact both in the ineffective assistance of counsel claim and as a standalone claim of actual innocence pursuant to Dellinger. This standalone claim of actual innocence has not been brought in a prior proceeding as it serves as the basis for Mr. Adams' attorney's deficient performance. Defendant Zach Adams provided the following alibi for his whereabouts and activities on the day of the victim's abduction, with numbers corresponding to the table below. Mr. Zach Adams woke up at approximately 7:30 a.m. and received a call from co-defendant Shane Austin, informing Mr. Adams that Mr. Austin had money to purchase Xanax and requesting Mr. Adams transport Mr. Austin, because remember, he didn't have a car, to make said purchase so they could engage in recreational drug use together. Mr. Adams did not have access to his vehicle at the time, as his grandfather had taken it from him the week prior because of that arrest. And then, where did I just... Okay. Mr. Adams asked his brother, Mr. Dylan Adams, to accompany them so they could use... Oh, I'm sorry. I don't have my screen shared. Sorry. My bad. All right, so we were here. To accompany them so they could use Mr. Dylan Adams' vehicle. Mr. Adams walked over to his grandfather's house where his brother lived and signed into his Facebook account from his grandparents' home while waiting for his brother to get ready. The Adams brothers picked up Shane Austin at his residence, and then the three men all went to the Shell service station off the interstate at Holiday, Tennessee to put $5 worth of gas in Dylan's truck so they could get to Parsons where gas was less expensive and fill the tank up there. While getting gas at the Shell station, Zach Adams observed 5 unmarked SUVs appearing to be TBI agents driving at a high speed towards the Parsons/Darden area, which he estimated to be driving 100 miles per hour. The 3 defendants next pulled into the Community South Bank through the back entrance of Long Drive, backed into the ATM so that the passenger window was facing the ATM kiosk, and headed back through the Long Drive exit towards the Delta Shell station in Parsons to fill the remainder of their tank. While at this station, Mr. Zach Adams observed Decatur County Sheriff's Deputy Tony Weber, who, remember, Tony Weber's like, I didn't see him that day. So Mr. Adams asked Mr. Austin to go into the gas station and pay for the gas, as Mr. Adams wished to avoid Mr. Weber due to a recent negative interaction with Mr. Weber. From there, the 3 defendants went to the rented home of Miss Gay White, a local drug dealer from whom Mr. Austin would purchase Xanax. Then they went to the Sonic and ordered food at the drive-thru. Next, they went to Joe's Video in Tanning, where Mr. Zach Adams' girlfriend, Rebecca Earp, was working. Mr. Adams and Miss Earp got into an altercation during this visit, prompting someone to call police on Mr. Adams, but no officers responded, presumably because all available law enforcement were looking for the victim at the time. As depicted below, in the table, defendant's alibi throughout the time of the victim's abduction was corroborated through multiple evidence sources, and counsel failed to adequately convey this critical data, which, if effectively presented, would have shown it had been impossible for Mr. Adams to have committed the crimes for which he was charged and ultimately convicted. So this table lays out the event, the timing, if available, and the evidence that was not used by defense or presented to the jury at trial. So Shane Austin, the contacts. We have Shane Austin's cell phone records communicating with both Zach Adams and Miss Gay White. Then we have this whole truck situation. And they're relying on trial testimony of Dick Adams, and then trial testimony of Billy Bell, who was a coworker of Dick Adams, who was holding Zach Adams' truck in Mr. Bell's mother's storage building at the time. So remember at trial, when the defense started presenting their case in chief, it's like we didn't have a clear picture with any of these tangible pieces of evidence. But they call Zach's grandfather and they call Billy Bell and they're like, no, we think we saw their car on the highway. And without all of this other stuff to corroborate the other points in time, do you think that's really compelling to the jury, just on their own, that they thought that they saw the guys driving by in the truck on the highway? But it makes sense if you have other stuff to corroborate other parts in the timeline. But that wasn't presented to the jury. So next we have the Facebook timeline. So that's going to give us 8:39 a.m. and 10:40 a.m. So Zach signs into his Facebook from his grandmother's computer. And there was an issue where it seemed like the prosecution team thinks that this activity was coming from a phone when it was really coming through like an AT&T internet account. And, you know, with AT&T, they give everything an account number and like a digital, it's a phone, it looks like a phone number, even though it's not a cellular device. So this Facebook records, Zachary Adams, and they're citing whatever page in the exhibits, and he posts, he says, let's see, you never was, you stupid whore. So, and then he's mad and he says, sorry for the bad word, let it slip, won't happen again, Mom. So he's having these conversations between 8:30 in the morning and 10:40 in the morning through Facebook. So for the state to say he's not sitting at a computer device during this critical timing when Holly Bobo's phone is moving and hers have pings, right? More accurate. For the state to have to argue, well, that wasn't Zach. That would mean somebody else would have to be signed into Zach's account and speaking that way on his Facebook account on his behalf. So, the three defendants get, yeah, so I think, let's see, where was it? They had both Facebook records and they also had records from like the internet bill or something. Like they had both. Like they had information that the computer was being used and then it's the user account on Facebook. So it's Zach Adams' account and it's coming from the computer device. So I don't know if that's coming from IP. Like right now I can go in and see where, I don't know, maybe not Facebook because I don't really use it, but something I use often and it'll tell you, you're currently signed in on a Samsung Galaxy device in Cocoa Beach and also a like Windows computer in Cocoa Beach. And sometimes it'll say like Titusville, which is north of me. But yeah, but they have like, it's a lot. And for the state to be like, well, we don't really know, he could have done that from a phone, someone else could have been doing it for him. That to me, they sound like a defense attorney trying to create the slightest bit of reasonable doubt. It's role reversal. Yeah, so I don't know why we didn't have this presented. Hey to Jennifer Sims, Merry Christmas to you. DB says, on the road today, sad. You could use the Brent Booth crying emoji. And hey, we got Jay Money in the building. Good morning. Hey, Lady L. Hey, Law Kong Express. I think Holly might have had cards, but I think the idea is nothing was stolen from her. Like, there's no speculation that anybody tried to take her money or her belongings. Her promise ring was found where her remains were, even though no, like, fingers or whatever were found. So if someone's looking for money or to rob somebody, you would think that stuff would be missing. So they've got, let's see, the $5 gas purchase. So they buy this $5 of gas in Holiday, Tennessee, and they have bank records for $22.02 point of sales charge at the Shell station in Holiday, Tennessee. So that's verified. So seems like they were being truthful, like very specific. I wonder if they kept their purchase receipt in a safe. Zach Adams observes TBI agents racing by in unmarked SUVs towards Parsons Darden area. This was around 10:20 to 10:45. And we've got law enforcement crime scene personnel arrival/departure time logs are consistent with Mr. Adams' eyewitness account. So again, that's something that could have been presented at trial. Like maybe through a detective that was saying, oh, maybe Brent Booth. Oh, it was the biggest mistake we ever made thinking that they were alibied. Well, didn't you... You questioned where the guys told you they were. You know, what steps did you take to verify or disprove their alibi claims? What about, you know, they told TBI that they saw these cars in the Parsons Darden area. Did you ever check? Could have asked. And that would give your client credibility without your client have to take the stand. We've also got, per first day summary, Craig Smith, THP Special Ops and Team, Wes Mays, and FBI Special Agent Bilnowski, FBI Special Agent Viveros, and JPD Task Force Officer Terry Buckley all report arriving on scene 10:30 to 11 a.m. Andy Rose arrives 11 to 10 a.m. Then we've got the Community South Bank ATM in Parsons. So Shane Austin said he withdrew $120 here. Could have lined that up at trial by saying, look, did you ever look at this $120 ATM withdrawal from Community South Bank? And it's not just any Community South Bank. It's specifically the ATM outside. It's not like they went inside and went to a teller. So you know that they actually drove through. And it's the Parsons one. So if this is like a chain, it's specifically the Parsons Bank. That's exactly which one they said they went to. So, oh, that would have been great. Like, just imagine, even just the chronology. If, like, every other column, like, not even all of this, but what if we did, like, every other thing at trial? And we're letting the jury connect some dots of the theory of an alibi to something that corroborates it. It just would have given the jury a timeline. So we've got, next up, we have defendants get additional gas at the Delta/Shell station in Parsons. So they've got the CB&S bank records for Shane Austin showing that he spent $9.84 at this Shell station, which is, I remember those days, just putting a little bit of gas in, getting to where you need to go. Zach Adams observes Deputy Tony Weber at this gas station. And then Decatur County charge records confirm Deputy Weber purchased gas at this station. So they could have confronted, because that guy, I swear Tony Weber said he wasn't there. He, like, denied. Because the idea would be, if Zach Adams can say he saw you there, and you were actually there, that's either a really, really good guess, or he's telling you the truth about his location where he was between this 11 to 12 time frame. And then it also makes the cop look really dumb. Like, or just in denial. Just in denial and wanting to stick with their theory that these guys must have done it, so I'm not going to concede, and I'm going to try to distance myself as far away as I can from anything that would help corroborate their alibi. So we've got Shane Austin purchases Xanax from Gay White, which is a crazy name. We've got TBI investigative reports confirming Gay White's residence at the time, 767 Georgia Avenue in Parsons, with house matching defendants' independent descriptions. So they all remember being there. So Dylan, Zach, and Shane all remember being there. They all described this house. So it's not like they just, Shane Austin went there and he was like, bros, you guys should say you went there too. Decatur County Sheriff's Office and multiple neighbor accounts confirming Miss White selling pills, including Xanax, Hydros, and Oxys, per 29 Lucy Gay White. Oh, okay, that's the file that they're referencing. I was like, did they name something after her? Lucy White stated that she does not remember Shane coming and getting pills from her exactly as described by Zach Adams, though she could not recall the specific date. Cell phone records between Shane Austin and Miss White, day of abduction, corroborate date of the abduction. Yeah, those cell phone records from Shane seem really important, because he was also contacting before they set off for the day, so it would corroborate that that's the reason Shane and Zach linked. All right, next we have defendants order food at the Sonic drive-thru, and that's all the way at 2 to 3 p.m. So they're saying they could have looked at the bank records for the charge at Sonic, and then they go to Joe's video, and I don't know why we didn't get this video. But if they're fighting at Joe's video, like a lot of this whole stuff about Victor Dinsmore, like confronting Jason Autry's testimony about going to Victor Dinsmore and this afternoon time frame. If we have somebody fighting, we're at Sonic in Parsons about 2 to 3. And then there's a 911 call at Joe's video at 3:27 because of the argument. Why don't we have that introduced? So they're saying they could have introduced the 911 dispatch log. It says Joe's video, Sandy wanting officer to come by video store. So that was the other employee that called. And then also the audio file, request for officer to Joe's video. So I think that was the 911 call. And then the jury doesn't get to see or hear anything about this stuff. So, am I Santa's helper? For one more day. Hey, Kelly, good to see you. Hey, Annie. We've got Sheriff Chuck's is doing a drive-by on Grey Gang. Oh, thank you, Sheriff Chuck. Oh my god, 20. Sheriff Chuck just dropped 20 in the chat. Santa Sheriff. Thank you so much, Sheriff Chuck. So a bunch of people just turned green. Make sure you are saying thank you if you very generously got gifted a membership. Super awesome. Sheriff Chuck has been just throwing it down all month long, making sure people are here paying attention to this case, which I love. And use those channel emojis, guys. We got a Doug Bates in there. We now have a Brent Booth. He's named TBI Cry. But use those till your heart is full. Thank you, Sheriff Chuck. We've got, let's see, referencing the petition for writ of error quorum nobis, which has at this point been denied, but they're saying, hey, back then, we already alleged that the trial counsel was significantly prejudiced. I mean, that Zach Adams was significantly prejudiced by counsel's failure to present to the court, through no fault of Zach Adams, 2 issues. To the extent the court finds that the defendant was, in fact, responsible for presenting this testimony, then the defendant alleges this failure was the result of ineffective assistance of counsel. So, if you think that we had all this information, or you think that defendant should have made it get pushed forward, then we want to take issue with Jennifer, Jim, and Jerry. Those are all J's, not doing so at trial. So defense counsel failed to present Lisa Sanders as a witness, whose testimony would have been that on April 13th, the day of the abduction, she was taking her children to school and saw a small tan truck driven by a man dressed in camouflage with black wavy hair and a mustache. Per Miss Sanders, he was a burly man who was definitely trying to hide something. Miss Sanders would have also testified that while driving, this man made a move to conceal whether or not he had a passenger. Miss Sanders remembered seeing the man's eyes and thinking something ain't right. Per Miss Sanders, the truck was heading west on Stokes Road in the Benton/Decatur County area. Then, about 2 to 3 days later, Miss Sanders saw the same man on a four-wheeler around her home. The man had a white box on the back of his four-wheeler. Miss Sanders followed him to Prospect Cemetery, where she saw the four-wheeler sitting unoccupied, and the man had gone into the woods. Miss Sanders told a friend, Bonnie Ham, who called the information into the referenced hotline, the TBI hotline. After watching the televised trial, which was 2017, so 6 years later, Miss Sanders confirmed the man she saw was Terry Britt. Petitioner further alleges that defense counsel failed to conduct a thorough cross-examination of Jason Autry's blatantly perjured testimony. Oh my god, that testimony kills me. Based his interview, Jason Autry made the entire story up to avoid what his attorney advised him was a 95% certainty of conviction. Again, the petitioner's position is that defense counsel was incapable of procuring either Mr. Autry's testimony or Ms. Sanders' witness account, and as such, the defendant was without fault. Let's see. And this is starting, I think this is going to be the same thing we saw in the initial petitions. So, defense counsel should have requested a testifying expert to educate the jury on distinguishing accurate first-hand recall and false and manufactured witness testimony. You know, things that Katie Spirko could speak to. As well as false confessions, the false cupcakes, procured through various police interrogation tactics. So again, the jury didn't hear those interviews with TBI agent Jeff Jackson and Brent Booth and Dylan Adams. They didn't hear those recordings with Victor Dinsmore, and they don't have knowledge the extent of which and the timeline of which, you know, these Jennifer Nichols proffer sessions with Jason Autry. And then the way the information could have been passed maybe to Brent Booth, who would go to Dennis Benjamin, or who would go and interview Victor Dinsmore and say, hey, here's what's going to be testified to. This helps me if you say this. Like, and you guys know that story by now. Wild stuff. The same expert could have discredited the ways in which law enforcement treated witnesses like Victor Dinsmore, Lisa Autry, and Rebecca Earp in its efforts to procure the same faulty and inaccurate reports. So, a lot on Valerie Trout and Rebecca Earp. These strong-arm tactics included, but are not limited to, arresting witnesses when they did not provide law enforcement the information they wanted, and threatening to remove a witness's children from their home. After procuring the sought testimony and witness accounts, these witnesses were subsequently rewarded with immunity agreements and the dismissal of pending charges brought solely to coerce such false testimony. Yeah, the unidentified woman. And calling Zach the defendant at times, just using language like you were reading reports. The defense counsel should have requested a handwriting expert or otherwise present lay testimony to show that the written statement of Dylan Adams was not, in fact, Dylan's, and therefore fraudulently obtained. Upon information and belief, the landowner on whose property the victim's remains were found was never called to testify that there had been multiple search efforts on this property prior to the remains being found. Moreover, the property owner would have testified that his land was known to be a place used by others, including some or all of the defendants, as a hangout where they would do drugs. This point should have been argued that it was reasonably possible the remains were placed there by some biased person and or organization in an effort to remove guilt on others and or frame the charged defendants. Now, this to me is huge, 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 huge. Do we have a shape here? Can I circle this? Let's just draw a big circle. Because it still makes no sense to me that the remains that are found are the skull, 7 partial ribs, a scapula, piece of a scapula, and then that's it. It just, something is odd. And then it's like, there's a story that Zach supposedly buried Holly Bobo. And the news throughout this whole time was showing this B-roll footage of law enforcement excavating in his backyard. And they're like, oh, we found bone fragments in his backyard. And none of that nothing had anything to do with Holly Bobo. No physical evidence from Zach's home except a bottle of nail polish that was a similar color to the color Holly was wearing. Like, can you imagine for real that their idea is, okay, can I customize this? All right, we found red nail polish this color. And Holly, we think she was wearing like this color that day, or maybe this color. And they're like, oh my gosh, this is incriminating. He, who has a live-in girlfriend, even though they were fighting at the time, he had a container of nail polish at his house, and it was like kind of close in color to what Holly was wearing. What kind of corroborating physical evidence is that? Let me get this stuff off my screen. So, but yeah, like, that's what they've got. But the news, if you watch the news, it would have seemed like, because of the timing of the arrest, TBI comes out and announces these search warrants on February 28th of 2014. And then on the 4th and 5th, we're getting this announcement that they've indicted Zachary Adams. And the news is showing all these pictures of the excavation at his house. And they're saying they got these search warrants. So if 97% of the community or the jury pool says that they heard about this case, and we saw that B-roll footage over and over and over as we kept going through the different coverage over the years, they're still using that footage. And you think, oh, search warrant, and he's immediately arrested and charged, and we heard that they got bone. You're going to think they found her there. And how do you walk that? That's very strong information, very compelling information. How do you unmarry yourself from that? So they found oxygen in his house. Oh no. Oh, he breathes. Oh, horribly incriminating. Everything is fine over here, says, what led them to her remain? Sheriff Chuck swooped in with the answer. The ginseng hunters. The hunter-gatherers. The ginseng hunters. Just crazy. Yes, and Montana Lil also says Jason Kilzer got shot by U.S. Marshals the week before the post-conviction hearings. I think right before the August ones, I think. I was listening to KF's testimony. Yep, I think Kathy Ferguson with a C. But yep. Crazy timing. Especially thinking of, do I have that handy? Jason Autry's, let's see. I don't know if I have it quick and handy. Yeah, I do. Jason Autry's PT Cruiser that's all shot up. I don't know. Law enforcement has a bone to pick with these guys, it seems like. Anyway, yeah, this part is especially crazy to me. That, you know, and I like to see it on paper. I like to see it. It's not something that can be easy, I would imagine, for a defense attorney to try to get anybody on the stand to talk about. I would love to see if he has enough to maybe hint an argument at this. Because this to me is just wild. We've got defense counsel failed to rebut Mr. Autry's perjured testimony with any evidence in the following ways. First, failure to present evidence in rebuttal of Jason Autry's false account of the way the alleged gunshot echoed. Testimony easily refuted. And I love, shout out to all the, like, I don't even want to say gun enthusiasts, but even like entry level, like 101 experience with firearms. The idea that common sense would tell you, because jurors, you can use your common sense when you're on a jury pool. You're instructed to. And so if you have somebody on the stand telling you, and the shots fired, boom, 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 and you know that that's not how a revolver, whatever the alleged murder weapon the state wants to pick, you know that that's not how that's going to sound. Like, you're BSing. So they're leading, like, the simple common sense point right here, easily refuted. Next, we have failure to provide a photo illustrating the scene where Mr. Adams allegedly shot the victim, so as to rebut Mr. Autry's false testimony regarding the visibility below the interstate by the Tennessee River. And I think you guys heard me say yesterday, there was like a photo they showed at trial where it's like someone's apparently standing at the shoulder of the interstate above and taking a picture, and they're like, oh, here's the scene. But yet Jason Autry's like, we went there because you can't see it from the road. But then the state or somebody at trial's introducing this picture where they're taking the picture from the road, and Autry's using it like, yeah, this is the exact scene. Obviously, it's visible. It makes no sense. It makes no sense. Then we have defense counsel failed to review flood records and or water levels from the day in question to verify whether Mr. Autry's story was possible with the water levels from that day. So, like, unprecedented rainfall in April of 2011. And the road is like, because this is under the bridge in between bodies of water, that gets flooded out. And there's also possibly, there may have been a gate that when the roadway would have been unpassable, the gate might have been locked. So cars couldn't pass. That might not mean people can't go and like walk down there. But the story is that this pickup truck drives out there. So, then we've got defense counsel failed to highlight the discrepancies between Mr. Autry's initial report to law enforcement that Shane Austin was holding a .357 Magnum and his subsequent testimony that the victim was shot with a .32 revolver. Now, anyone that's new to this case, gotta say it, a .380 auto casing was found next to Holly's skull. And one step further, there's also a possible connection to a .380 with Dylan, where maybe they thought they were going to try to pin something on Dylan Adams with that whole Jason Kilzer arrest. And maybe that's how this shell casing gets there with the rest of the remains, if they weren't there since the day of the abduction, if they were later placed there. There's something curious about this .380 casing either way. But doesn't matter. Autry has this ever-evolving murder weapon story, settles on the .32 revolver for the time of trial, even though the casing next to Holly's skull is a casing, and revolvers don't eject casings. Mr. Autry's altered testimony curiously conformed to the evidence presented regarding the casual exchange between Shane Austin and Victor Dinsmore involving a .32 revolver, which the state did not credibly prove was the weapon used to kill the victim. Defense counsel should have issued a subpoena to Michael Scholl and or Mr. Robert Paris for all communications they had with the prosecutors in this case regarding Mr. Autry's testimony and forced them to testify at trial, and called General Jennifer Nichols to develop what exactly leniency meant. Yes. This is huge to me. Plea deals, the weight and pressure of a plea deal is something that any trial that we watch, I analyze a lot. I put a lot of weight into whether or not I think somebody could be saying what they're saying on the stand, because it could shave a year, 2 years, 10 years, a death penalty off of their sentence. So this is a critical point for me personally. And trial counsel wasn't able, they didn't do the work to get there. But yeah, what exactly did leniency mean as stated in the transcript the state was offering for Mr. Autry's statements? Then we've got defense counsel should have gone into greater detail to explain the DNA analysis of the hair found at Terry Britt's home, including the potential for new, up-to-date testing of the same. And we didn't get any of that. Defense counsel should have requested the spent .380 cartridge found at the scene near the victim's remains be tested for latent fingerprints. I didn't know it wasn't. Ugh. All right. A little bit about voir dire. Ineffective assistance of counsel. Ms. Thompson inadequately conducted voir dire / jury selection. Her attempt to use the Colorado method was misplaced in this case and set the mood immediately that the issue in this case was whether Mr. Adams should be put to death, not whether the jury could appropriately determine guilt or innocence. Oh. At trial and generally speaking, Ms. Thompson's manner of presentation, inability to communicate effective points or of defense, or highlight through persuasive argument and forceful cross-examination, all combined for a harried, unfocused, discombobulated and poor defense of an innocent man. Specifically, counsel was ineffective further by the following. Defense counsel failed to illustrate for the jury the manipulated testimony and the multiple fallacies presented as credible evidence in the following ways. Dylan Adams, whom it is undisputed suffered from intellectual deficiencies, was coerced into a plea deal in a federal case wherein he was forced to live with Dennis Benjamin, a retired detective from Memphis who was coincidentally working for the Holly Bobo family in their search to find Holly. Dylan Adams was then pressured and manipulated by Mr. Benjamin into thinking he was involved in the victim's murder. It was only after Dylan was placed in Mr. Benjamin's custody that he allegedly confessed. If the state's theory of the case is correct, then Dylan's entire statement was a lie. Or, as the defendant will show, they were all lies. Regardless, Dylan's false statements and coerced confessions formed the bedrock of the subsequent investigation, and all matters regarding Dylan Adams's and Dennis Benjamin's involvement should have ultimately been exposed by proper pretrial discovery and during trial presentation of evidence on this thematic point. Isn't it crazy? Like, I think we've gone through like 2 or 3 pages since the table. Maybe 4, 5. All right, we made it a little bit. But it's just like there's so much here. Like, it's like, oh, the 380 casing. Oh, the way the remains were found. Oh, the ATM alibi video. Oh, yeah, Dennis Benjamin. Oh, yeah, Terry Britt. Oh, yeah, Victor Dinsmore. Oh, yeah, 10 different murder weapons. All right, then we've got Shane Austin provided no real confession other than corroborating what TBI officers and agents represented to him as statements made by Dylan Adams. Well, no wonder Shane, oh my God, Shane never had a chance. They told him they'd give him immunity if he could get them to the body, told Shane what Dylan Adams said after Jeff Jackson and Brent Booth have him in these long interrogations telling him what to say. So basically, Shane Austin, he wasn't able to point correctly to anything because he was working off information that TBI fed Dylan Adams. Like, this is crazy. So he's obviously unable to provide the state with the location of the victim's remains because he simply did not know. Jason Autry then offered up a better, more polished story, and through his masterful raconteur personality. Oh man, we're gonna have to watch more Jason Autry. Was able to weave the discovery evidence and important cell phone records into a plausible timeline by simply adding that the victim's presence to the actual events of this day. Nonetheless, Mr. Autry's story had significant gaps and points of deception, of which the defense counsel failed to exploit or capitalize. In its cross-examination of key witnesses, defense counsel's performance was both lackadaisical and rambling, resulting in an ineffective, unclear, disorganized, and unpersuasive presentation. Defense counsel failed to cross-examine Brent Booth in his statements that Karen and Dana Bobo lied throughout the investigation, and this is critical in multiple ways. Those are 2 witnesses lying. Those are 2 witnesses that are very close to the victim lying. But worse than that, you have Karen Bobo, who's having conversations with Dennis Benjamin, retired Memphis police officer that Dylan Adams, as a probation condition, has to go live with for 5 weeks until he miraculously confesses and is dragged down into the TBI office to plop him in the seat and be told what to say by Jeff Jackson and TBI agent Brent Booth. But you have Karen going door to door, speaking to the whole town, relaying to them, asking them questions. Do you know anything about this? And those questions are containing information that she's learning through the private investigator work that Dennis Benjamin was doing and any other leakage from TBI and or other law enforcement agencies. So she's contaminating the entire community of witnesses. Meanwhile, this entire community of witnesses is trying to piece anything that they know or learn into a way to solve this mystery of what happened to Holly Bobo. So, defense counsel failed to cross-examine Brent Booth on his statements that Karen and Dana Bobo lied. Failure to retain a ballistics expert regarding the defect size in the victim's skull versus the .32 revolver and the .380 found at the scene of the remains. Defense counsel failed to effectively argue or reconcile the discrepancies between said defect and that which would have been made by either weapon. Further, defense counsel failed to point out that the state did not test this .380. Failure to properly utilize key witnesses such as John Walker, Art Viveros, and Terry Dykes, whose testimony could have shed considerable doubt on the prosecution's case, and the complete failure to capitalize on the assessment from Mr. Dykes' investigation. Failure to introduce the multitude of other false confessions procured from other people throughout the course of the investigation. And we've gotten to hear a little bit hints about Rebecca Earp. We've had a lot of deep dives, shout out to Trial and Error podcast, on, what happened with Dylan Adams, what happened with Victor Dinsmore. But I'm curious what else is there. Because I would not be surprised if there's like 5 more people we could go through. And they've got another story of false confessions being spoon-fed. We've got failure to introduce inconsistent statements from Clint Bobo. So, remember, that's Holly's brother. And the expressed opinions of law enforcement that he was dishonest, including law enforcement's recorded document to this effect. Oh, so it's not just, it's written and memorialized. You have a report and you didn't use it. Oh, Max Shart would be so sad. We have failure to object to the dermatological assessment of the scars on Zach Adams' arms. Yeah, so remember they were saying, they were trying to interpret what the scratches on his arms could be from, and the entire chat was like, those look like scratches of someone that uses. And they're fresh. On the 23rd of April, they look fresh and pink. Not scarred over. But it's supposed to have occurred on the 13th, 10 days earlier. So they say, we failed to object to the dermatological assessment by someone that is not an expert in that area, which were introduced by the state through non-expert testimony. Additionally, the failure to solicit testimony emphasizing the inconsistent appearance of the scars with those which would evidence a physical confrontation consistent with the crime. And again, you guys remember me trying to demonstrate, the scratches that run linearly up the sort of inner side of the forearm are not what I would expect to be inflicted upon someone if I'm trying to get away from you. That's not, I would think it'd be curving around. But he has these linear scratches sort of on the inner curvature of his arms. Even his picture, it's like his palms were facing out when he took the picture, which means your arms are rotating. Pull the Shart alarm. The Shart alarm is crazy. We gotta say Max Shart, so we know. And we're not saying something else. We've got failure to cross-examine Mr. Ernest Stone. Oh, so this is Ginseng Guy. What happened here? Failure to cross-examine Mr. Ernest Stone about all particularities of the day on which he found the victim's skull, including Mr. Stone's criminal record and or prior dealings with the sheriff's office. You guys have talked about this. You guys are like, what if he knew somebody? And here we're getting the hint. It would be Doug Bates has a duty of candor to the court. I don't think he could just throw this out there as a random guess. He's not Tyrone Blackburning this. So there's likely a basis of information upon which Doug is saying, hey, this is something that a defense attorney could have presented to create reasonable doubt or get after Larry Ernest Stone's credibility at trial. around a critical piece of, or a critical event, the finding of Holly's skull. What, 7 days after Sheriff Keith Bird is elected? Family friend of the Bobo family who says he's going to get on there and put this thing to an end, and he does so in 7 days. Oh, Jesus. So, Trial and Error Podcast says Ernest Larry Stone, or Larry Ernest Stone, that he got his criminal record, including pending charges, wiped after discovering the skull. Did he have to go live with Dennis Benjamin? Like, I still can't get over, guys. Yesterday we learned that Jason Autry, his time served deal, they didn't even make him pay any type of restitution, fees, or fines. Just crazy. Hey, sunshine for you. Good to see you. Good to see you. I always love when I look at the chat and I see someone coming in like, hey, and I'm screaming at the screen. I'm going on a tangent about something. I'm just yelling and someone just comes in all polite saying hello. Oh, man. So I would have loved to have seen all this play out. Ask Mr. Larry all of it. Oh, my goodness. That's what I'm saying. You know, I would love for this just to be put to an end. Like, state, you suck. We're overturning the conviction. Like, oh, we're too stupid. We don't have enough evidence. We don't want to do a retrial. Like, that's the outcome I'd really love here. But if there's a retrial and we get to see a different strategy, different approaches on all of these different witnesses, it would be something. It would be something. We've got failure to call Matt Stowe. So Matt Stowe was also elected and took office on September 1st. So took office the same day as Keith Bird. So they should have called him as a witness. So he became, like, I forget how they call it, like the district AG or something like that. District attorney, deputy attorney general. Like, you guys have weird naming schematics over in Tennessee. But he was basically boss of the prosecution teams in a district. And within a few months, there's a bunch of infighting. But he takes office September 1st. Keith Bird takes office September 1st. And then they suddenly have action in this case, finding the remains after they found nothing since the day of the abduction. Even though U.S. Marshal John Walker, who has done great work working with the Fugitive Task Force, nobody wanted to trust his logical guess, his analysis, his conclusions on the best place to go and look for the remains of Holly Bobo. And turns out, even though they find it years later, he was right. They were there. But they find this September 7th, 2014. The timeline is just ridiculous in this case. Then they've got failure to argue the deficient size of the vehicle Zach Adams and Shane Austin were allegedly driving, and failure to illustrate how said vehicle would have been too small to transport the defendants and the victim. So they were driving, I don't know, was it supposed to just be like a 2-seater cab? Something like that. So we've got failure to pursue lines of questioning. The whole truck thing is a mess to me because the witnesses changed their version of what truck they were seeing, what color the truck was, what size the truck was, whose truck owned it, if the truck was there or not. So there's so much wrong with all of the witness accounts or, you know, fabricated storylines. There's so much inconsistency about all of the vehicles mentioned. We've got failure to pursue lines of questioning during the cross-examination of Jason Autry. And did they ever ask Terry Britt about him painting the truck at trial? Did the jury get to hear about that? I can't remember. But, like, all of this truck stuff, and then you have Terry Britt, a local sex offender with a history of doing this type of thing, just painting his truck, cutting his ponytail. Wife leaves her job at a news station the day of the biggest news story. Just doesn't go back, just goes home to hang out. Weird story with the Brits. So, yeah, Gigi says Beth Boswell said that all Marshall Walker did was sit and look at his map. Yeah, Aaron, this is true too. I agree. I feel like Stone said something weird on the news as well. Like he was always looking for Holly while ginseng hunting, and he said it was like divine intervention. And there was even motion in limines about like not making mention of divine intervention at trial. So, which I'm not saying like, I would imagine like, I feel like it can be normal for people to say, I don't know what made me look in that direction, but something made me look, right? That can be a normal thing to say. But when I consider it in the timing, it's like, did somebody tell you something and that's why you went hunting for ginseng in that area? Like, did someone just say, hey, that's a good spot to go look for ginseng? And then that's how we get there? I don't know. So maybe there was intervention there, right? And it wasn't like something that maybe was direct, like, hey, go here and go find a skull. But hey, go here and go look for ginseng. I don't know. And then they wait like 2 days to go and actually walk the scene of the area. Okay, and HTX Voodoo says she did ask about painting the truck, but she said spray paint, and he said it was a paint gun. Oh, yes, there was like the quibble. And that means the witness is in control. Like, he was just pushing back, and his demeanor was crazy. But he did push back. And if the jury was already not trusting the defense's theory of the case, I hate to say it, but I wonder if that might have made Terry Britt look compelling. Even though he's conceding that they did paint the truck. Which is just wild. Yeah, and when Larry Stone called, he said it looked like a woman's skull. Oh, yeah, and we didn't really, the jury didn't get to really hammer home the issues with all the different phones. He's not even supposed to have phones. They got to hear, of course, he had a device and they bought minutes at Walmart. I don't really think that was fully fleshed out. It's just crazy. This is what I mean. Like every turn, there's like another wild thing about this case that I got to remember. I'm like, oh yeah, about that thing. All right, so we've got failure here to pursue lines of questioning during the cross-examination of Jason Autry that would challenge or otherwise rebut Mr. Autry's clearly exaggerated and perjured testimony, including but not limited to his statements that he previously found another body at the same location as the victim's remains, but never reported it to law enforcement. It's not for nothing. I think that's a viable moment. So let's say, for example, there is no alibi. Well, there's a lot that would show still the testimony of Dylan and Shane, so much butterfly effect here. Things could have been so different if this was tried earlier. But like, I think there's a way, even if all four of these guys intermingle on this day, rather than Zach and all three of the others, or Zach and Dylan, or Zach and Shane, or Zach on his own, but then bringing Autry to move the body, I think there's actually a pathway for Jason Autry to look like the third-party culprit. And so to not push back on Autry, like, that's a very sus thing. You just saw a dead body, you didn't report it, and then you're also, a few days after the abduction, you're apparently willing to kill Dylan Adams? Like, are you a killer? Do you have a pattern of this? Like, let the jury marinate in something like that. Because maybe Jason Autry could have been over there. Maybe he was the one. If we're supposed to believe Jason Autry, maybe he's the one that was actually putting a bullet in the back of somebody's skull. Like, there's just something so just unbelievable about Jason Autry that he looks suspicious even if he didn't do this thing. And I think defense attorneys, you could have capitalized on that. But instead, what we had from Jennifer Thompson is, instead of going with the strategy of somebody else did this and not my client, she hunkered down on this person did it, Terry Britt. But she wasn't able to flesh that out in a convincing way. Like, I think focusing on Terry Britt would be very compelling if it was done the right way. But she set her sights on trying to convince the jury it was Terry Britt and nobody else. And she spends 25 minutes in closing outlining how other people were excluded, with the purpose of saying Terry Britt's not really excluded. But I don't think it landed. I just don't think it landed. And really, I think Autry could have been in that list if a defense attorney wanted to make Autry look sus. I think Autry alone is reasonable doubt with this body story. So, we've got failure to question Mr. Autry as to why he had not pled to anything regarding his alleged involvement and why he continued to insist on proclaiming his innocence to the charges. Further, defense counsel should have asked whether Mr. Autry had been charged with attempted murder of Dylan Adams. Like, that's crazy to me. Body floating, you've seen it previously. Why was the body that you don't report it? And then you're also willing to kill Dylan. Like, you look sus. And the jury's not set up to marinate in that. So we've got the defendant incorporates the entire affidavit of Terry Dykes attached to this motion for a new trial to illustrate on its face that any jury would have believed Mr. Autry's testimony simply due to the ineffective cross-examination by defense counsel and the lack of evidence submitted by the defense at trial. And I think what we'll do with this stream is maybe we'll read the Dykes affidavit. And even though we only got through one motion, this is a long one. So that will be how we package this one up today. We've got a lot of underlining here. We have failure to proffer the following simple dichotomy of the proof to the jury. Mr. Autry said Zach Adams and Shane Austin were at the Bobo residence to teach Clint Bobo how to make methamphetamine. If true, Clint Bobo obstructed justice for years and lied repeatedly about the day his sister was kidnapped. Conversely, if we are to believe Clint Bobo and his story, it is Mr. Autry who is placed on the stand to lie. It cannot be reconciled either way. Oh, that's interesting, Montana. So Boswell or Ferguson said a boater named Ham heard a gunshot, but a female with a last name Ham, I think you're thinking of Bonnie Ham, was going to alibi Zach. Are you thinking, was it Bonnie Ham? Was that her name? But to be fair, there are a million overlapping names in this case. Hey, Curiously. Merry Christmas Eve. Good to see you. We've got significantly defense counsel's failure to allow Zach Adams to testify. Ms. Thompson stated in a subsequent interview that Zach really wanted to testify. Ms. Thompson coerced Mr. Adams into not taking the stand, thus denying Zach his constitutional right to testify in his own defense. Failure to call Jason Autry's attorneys and demand information pertaining to what Jason Autry was being offered in exchange for his testimony. Additionally, failure to request non-attorney client privilege, especially after the state opened this door slightly, communications from the lawyer to Mr. Autry. And then we've got miscellaneous issues. Defense counsel failed to seek recusal of the court itself and or request disqualification and removal from the proceedings of the court officer, Anthony Alexander, who was not only listed as a witness on the TBI investigative report, but upon information and belief, is Dana Bobo's first cousin and therefore related to the victim. Mr. Alexander and Dana Bobo are also believed to be business partners with ABC Cleanup. Oh, moreover, upon information and belief, Mr. Alexander had direct engagement with the sequestered jury. I think we heard mentions of that in the initial petition, but I don't think that this was as fleshed out. Ms. Thompson should have been more aware of the landscape of this case and realized how little confidence and trust the court had in her capabilities as a trial lawyer. She was attacked by opposing counsel as well as fellow defense attorneys and lost confidence in herself and in the case. Subsequently, this resulted in a significantly flawed presentation of the evidence as well as her opening and closing statements, which were sorely ineffective. She should have either withdrawn as counsel or aligned herself with a competent attorney with some semblance of a working relationship with the trial court and her prosecution. Ms. Thompson's choice to bring in Luke Evans was a disastrous move in which she lost the confidence, if any remained, of the trial court. And I'll say, we're going to see attached like some of her billable hours. Like, she details her billable hours. She tracks everything. She logged quite a bit of time across like February, March, April, leading up to trial, dealing with this Luke Evans issue. So it, got to be consuming your time and mental energy. We've got further, Miss Thompson failed to plan for the logistics of this trial. The court advised it would not force the state to tell the defense which witnesses would be called the next day. Uh-oh. I think it's actually good they're framing this as IAC. Miss Thompson continued to keep the voluminous boxes in her hotel and would thus have to go and retrieve the boxes when a witness was identified. She spent much of the direct examination hurriedly going through the portion of discovery pertaining to the testifying witness instead of actually listening to the witness's testimony and preparing for an effective cross-examination. As a result, her cross-examination often came off as perfunctory impeachment without a point. All right, so this is going to get through. He's denied his opportunity for a reasonable defense, competent defense, due process denied. He was prejudiced. It was an unfair and unreliable result. And that I like the wording here. There would have been a difference, right? So had Mr. Adams been represented by constitutionally effective counsel, he would have received a vastly different result at trial. So specifically, defendant presents the following. So we have the new evidence. Upon information and belief, the petitioner was captured on an ATM recorder the morning of the victim's abduction. The recorder was never sought, but clearly exists, as once the defendant began discussing retrieval of the recorder with the bank's liaison, the state subsequently seized the recorder to hold for themselves. The state did agree to provide a copy and a subsequent motion that will be filed to capture the original for testing if necessary. Suffice it to say, such information, once obtained from experts, will prove by clear and convincing evidence that the defendant is actually innocent. Further, counsel had just found out that the state already reviewed the ATM data in 2011 and that Terry Dykes was one of the agents responsible for viewing this footage. So remember, they're going to say later that Brent Booth is going to say, it was the biggest mistake. Meaning, referring to their position that Terry Dykes alibied individuals that didn't really have an alibi. But Terry Dykes, among other things, relied on this ATM data to alibi the guys. Then alibi stuff is unavailable at trial. Brent Booth says it was the biggest mistake that Terry Dykes went in there and alibied these guys, or said that they were alibied. So this was in May of 2011, and neither Zach Adams, Dylan Adams, nor Shane Austin were persons of interest when this footage was viewed. Upon information and belief, a log was created that summarized the vehicles. Generically, no license plates were recorded, carrying passengers going to the bank's ATM machine. A multi-page log was created, however. The pages of the log's time frame in which both Mr. Adams, Dylan and Zach, and Mr. Austin purportedly went to the ATM has not been found. This is a fluid issue at this moment that will be updated. So remember, we're still back in November of 2024. Because this is, let's see, response. $11/25, so November 25th. And we've got, let's see, Trial and Error Podcast says, Clint was the DCS worker of the woman who initially made the claim against Zach for his February 28th, 2014 arrest that morphed into the Bobo charge. Welp. Welp. Well then. Shout out to Derek for the super sticker. Thanks, Derek. Hope you're doing well. If you're celebrating today, hope you're having a good one. It's just crazy. Yeah, there's a lot going on with this Rebecca Earp, Valerie Trout, and I really don't think that was conveyed at the trial. I don't think that was conveyed at the trial, that there was serious pressure. It was mentioned. I don't think it was lackadaisical. It was lackadaisical. It was dicey. All right, so again, this sketchy thing with the subpoena gate and this device, this equipment. So Terry Dykes, perhaps not knowing that he's supposed to be looking for a particular truck, but he remembers looking through footage. So what that means is knowledge that what is available to Zach Adams in this 2024-2025 subpoena gate era, Terry Dykes recalls, hey, I think I watched a video. It was just playing through and you could see multiple cars and there's one that backed up. Maybe that's what Terry Dykes can remember, but back then he might not have been saying, all right, let me get this license plate and let me look at these individuals because they weren't persons of interest yet. And that's crazy because right now the state has only turned over still frames, a series of still frames. Next, we have the petitioner respectfully requests this court and perhaps the appellate/Supreme Court to extend the predicates of Dellinger v. State to the recantation of Jason Autry and how it proves in this standalone petition that Mr. Adams is actually innocent of the crimes for which he was convicted. We've got neither of these claims have been presented in a proceeding before. The ATM data was sought by the defendant and advised that none existed. Thus, they did not understand that it did exist and that the state had even reviewed it. Mr. Autry's recantation occurred in 2023 and was the basis for the petition for writ of error claim that was denied based on the statute of limitations issue. And let's see. They're going to go, we've got substantive due process, Brady violations, and prosecutorial misconduct. So in addition to the ineffective assistance of counsel and the idea that this new evidence has never been shown in a proceeding before, we've also got due process, Brady violation, and prosecutorial misconduct issues, denying Zach Adams a fair trial under the 14th Amendment and Article 1, Sections 8 and 9 of the Tennessee State Constitution. So, first we have a specific lie known to be false by the state, not to be confused with factual lie O'Bailey's. We have specifically, the petitioner cites the above referenced testimony of Jason Autry, wherein he stated that Zach Adams told him he and Shane Austin were at Holly Bobo's house to teach Clint Bobo how to make methamphetamine. It is unclear who the state thought was lying, Zach to Jason or Jason to the jury. However, what is clear is that the state could not have believed Mr. Autry's recitation of these facts, or it would have had Clint Bobo arrested for obstruction of justice and never would have presented his testimony at the start of trial. While the state did relay the evidence was, quote, not being presented for the truth of the matter, that distinction is intended for Rule 801 hearsay objections and not to allow false testimony to go uncorrected. This amounts to prosecutorial misconduct and the admission of such untrue evidence significantly prejudicial effect on the verdict. The defense submits that this issue, item 39, was not presented in any claim for relief because of either Ms. Thompson's constitutionally deficient performance and or the full extent of the Mr. Autry's deceitful testimony were not understood until he recanted in December of 2023. So we got Jason Autry as a state agent and misconduct. Moreover, at this point, any grounded trier of fact now knows that all of Mr. Autry's testimony was false. While the prosecution may have been fooled to believe that Mr. Autry was telling the truth, Mr. Autry clearly knew he was lying. And Mr. Autry so ingrained himself into the prosecution, and the prosecution affirmed Mr. Autry's participation by agreement, that Mr. Autry became an agent of the state in the prosecution of Zach Adams. Such perjured testimony by a state agent violated Mr. Adams' due process rights because the term prosecutor encompasses actions of government agents for which the prosecution must account. Now, this is an interesting argument. They're saying their interactions were so interwoven that Mr. Autry, his testimony was, in essence, delivered within the capacity of an agent of the state. That's like a layered argument there. Okay, Rick says it wasn't all false. He got up there and said, "My name is Jason Autry." So, we've got, where were we? Term prosecutor or prostitute if you're Beth Boswell and just use the changes interchangeably. Jason Autry became an agent of the state in the same way third parties can become agents of the state to the extent their interactions with the defendant violate their Sixth Amendment rights to counsel. Specifically, Mr. Autry and the state had multiple meetings in which there was an explicit agreement for Mr. Autry to act as an agent of the state in testifying. While the prosecution presumably believed every word of their new agent, Agent Autry, Jason Autry knew otherwise. Thus, he was an agent of the state who knew he was lying, and such lies were of vital importance to the rendered result and material to the defendant's conviction. They cite here State v. Willis for the discussion of how third parties can become agents of the state. The defense submits that this issue, item 41 and 42, has not been presented in any claim for relief because of either Ms. Thompson's constitutionally deficient performance and or the full extent of the Mr. Autry's deceitful testimony were not understood until 2023. The defendant also submits it was a Brady violation to withhold from the defense what parameters of sentence negotiations the state was prepared to enter with Mr. Autry and what informal negotiations had taken place during the same. I wouldn't lie to a jury. Do I need to put up the picture? I need to move these pictures up for quicker access. I've got a lot going on here. I've got a quick poll if you guys, we talked about the different firearms. Since I'm seeing that, maybe that was worth pulling up. I should have pulled that up earlier. And how a 380 auto casing, what's actually ejected is only 0.355 inches and would fit pretty nicely into a 0.36 inch diameter defect. Where's my Jennifer picture? That's all I want for Christmas. I think I deleted it. Oh, no, I didn't. Oh, good old bad Jennifer. We've got, let's see, the Brady violation, Autry, the negotiations, and also, are they going to mention... I think Giglio would also be good to mention here. I know there's overlap with some Brady and Giglio, but I think I would have cited both. Come on, Doug. Give us Brady and Giglio. But in 2020, well after the jury verdict and after the court denied the motion for new trial, Mr. Autry received only 8 years. That, with time served, effectively allowed him out of jail within weeks of his plea. Further, this sentence was run concurrent with an unrelated federal charge. The defense asked for this information, was never advised by the state on what sentence they were prepared to release Mr. Autry. Such evidence was favorable to the defendant, and the evidence was material. This was a violation of Mr. Adams' procedural and substantive due process rights under the 14th Amendment and the United States Constitution and Brady v. Maryland. So the defense submits that this issue was not presented in any claim for relief because the event that revealed the need for Brady disclosure, Mr. Autry's plea deal, did not take place until after this court denied his motion for a new trial and the matter was traveling through the appellate process. So that's a lot of this was we saw this in the previous versions of the petitions. I love this. So I, Douglas Bates IV, certify that I have thoroughly investigated, and it's underlined, under the circumstances of the voluminous discovery, the possible violations alleged by petitioner, including all those in the original and amended and this proposed second amended complaint, and any other ground that petitioner may have for relief. I have discussed other possible constitutional grounds with the petitioner. I have raised all non-frivolous constitutional grounds by existing law or a good faith argument for the extension, modification, or reversal of existing law which petitioner has. I am aware that any ground not raised shall be forever barred by application of the Tennessee Code Annotation Section 4030-106G, and have explained this to the petitioner. So we want a new trial, or alternatively dismiss all pending charges against him for the relief cited above. Schedule this matter for an evidentiary hearing, blah, 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 blah. And there we go. So that was, and again, this was attached as this motion to file. He wants leave to amend, so. Then next, a few days later, let's do these because they're short. It's additions to the proposed second amendment. So now we're on December 2nd. And hey to everybody coming in. Hey, Amber. Hey, Philly. Good to see you. Good to see you. Hey, Charlie. We really read through a motion. So a lot of it is, well, actually, I think some stuff was new. But it was really the first time we got to see Doug Bates lay out those issues in writing, because he's working with some information that's been clarified since he initially filed the petition. So, and then we've got, let's see. All right, so 35, they want to add these amendments. The evidence of Mr. Zach Adams on the CB&S Bank ATM recorder is scientific evidence in nature such that proves actual innocence and is ripe for this post-conviction proceeding pursuant to Dellinger v. State. To the extent it is deemed to have been waived because Mr. Adams' counsel did not bring this issue up at trial, then such was because of the ineffective assistance of counsel. So we're not going to we're not going to have this court tell us, like, hey, I think there was a problem here, but you didn't raise the right issue. You didn't use the correct analysis. In December of 2023, Mr. Jason Autry provided new information in this case to show that Mr. Adams' constitutional rights were violated by the state's prosecution of him, based on various theories espoused below, that a void and or voidable and or unreliable result occurred because of the abridgment of certain rights guaranteed to him by the Constitution of Tennessee and or the U.S. This includes ultimately his procedurally due process rights under the, I don't know, I'm struggling. I don't want to say 14th. I know it's 14th, but my eyes want to switch it to 16th. 14th Amendment and Article 1 of the United States Constitution, Section 8 and 9 of the Tennessee Constitution. Based upon the principles of prosecutorial misconduct and violations of Brady v. Maryland, both of which were revealed in Jason Autry's December 2023 hearing. Hearing or interview? At no point were these issues waived because the defendant did not have access to this information during his trial or appellate process, nor has any court addressed the merits of these claims in a full and final hearing. Mr. Autry thus revealed that A, the state prosecution and him ingrained themselves to such a degree that Mr. Autry became an agent of the state in presenting false testimony, and that B, the state prosecution did in fact convey through his attorney sufficient enough of an understanding that Mr. Autry's sentence would be what Mr. Autry's sentence would be if and when he testified, and that should have been disclosed. The recorded interview factually the following. So I think they are talking about the December 2023 interview. So he admitted to concocting the entire story in his cell at jail while reviewing the discovery and in discussions with his attorney about the best way to avoid spending the rest of his life in prison. This story was what he presented at trial. He admitted that it was all false, that he used the extensive cell phone data provided in discovery to create a story around it. He said he just recreated his day and added Holly to it. He acknowledged it was all to get him out of jail at the express guidance from his attorney. At one point, he said, "We put it together in 3 days. It is unclear exactly who we were, but it is believed that at the very least, his attorney and or private investigators were involved." Further, per his recorded interview, there were discussions between his attorneys and the state spent days with him in investigating his story and forthcoming testimony, which we now realize is false based on the December 2023 interview. That's the timeline, you guys, where we lead up to that unmemorialized proffer session that doesn't get memorialized until like 2 months later, and after Brent Booth has his back-to-back conversations with Victor Dinsmore, all about what's going to be testified to and what Jason's going to say. Mr. Autry further explained how details of his story came to light, including parts of the story, how he created the story about the gun from an incident with Terry Britt. Oh! The court said Mr. Autry's testimony was some of the most credible and persuasive testimony the court has seen. That's that clip of Judge Creed McGinley pausing Paul Hagerman during the plea colloquy. Further, Mr. Autry said he was very well trained by ADA Jennifer Nichols, whom he referred to as the boss of it all. Mr. Autry's plea deal. Most importantly, at Jason Autry's plea deal, and I think some of this has been in the motions, so I'm wondering if this filing, this addition to proposed Second Amendment to the petition, maybe they just forgot to include it. But yeah, this occurred just after Mr. Adams' motion for a new trial was denied, and that is underlined. So the deal is sealed. We're all good to get Autry, get the ink dry on Autry, because we don't need him anymore. We don't need to have this risk hanging over his head that we can yank away at any time if he doesn't do what we need him to do. Adams' motion for a new trial was denied, so let's move him forward. So Assistant District Attorney General Paul Hagerman said that Mr. Autry's testimony answered many questions that were left open factually in the investigation, and many questions Karen and Dana had with what happened to their daughter, and it was a very important piece of getting justice for Holly. So this is a very important quote because it contradicts the state's arguments throughout these proceedings that, well, even without Jason Autry, there was a mountain of evidence, all of these other witnesses that corroborate Zach's guilt. But here you have them saying at a plea hearing, representing to the court, that Jason Autry answered questions that were left open factually. During this plea deal, the court stated that Mr. Autry's counsel told him, "We will not need a trial date," and that was February 1st of 2017. That we knew of that already. At that hearing, they say that they were aware, the court was aware, and the state knew, and Jason Autry's counsel knew that they would not be needing a trial date for Jason Autry. Though it clarified, defense counsel became incredibly technical, saying the state has provided no formal offer, saying nothing as to what was informally offered. It is submitted that the informal offer and plea discussion referenced below as to what the state was prepared to enter was Brady material that was unknown at the time of the trial and not subject to appellate review. Yeah, huge issue there. I think that's a huge issue. And again, I think plea deals, the influence of plea deals, pressure, whether or not if you have outstanding charges or you think you're at risk of having charges brought against you, a huge compelling reason for someone to either agree to cooperate at all or change their story, morph their story. Next up we have, let's see. Okay, this was December 2nd. And then next it's a motion response to Petitioner Adams' motion to conduct a Zoom hearing or in-person hearing with Jason Autry to determine if he waives his attorney-client privilege. So this is the state of Tennessee saying, let's see, that according to the code on post-conviction procedure, Each party shall have the right to subpoena witnesses for appearance at the evidentiary hearing, and that no authority exists in the code that would allow Petitioner Adams to compel Autry to testify in any hearing outside the post-conviction evidentiary hearing. Counsel for Petitioner Adams can easily communicate his questions regarding Jason Autry, waiving the attorney-client privilege, with his trial counsel by contacting Jason Autry's current attorney, Miss Elizabeth Ann Eric, who is presently handling Mr. Autry's direct appeal in the U.S. Court of Appeals for the Sixth Circuit. So he's got some litigation he's dealing with. This appeal concerns Jason Autry's 279-month, this was the upward departure, over 23 years, sentence imposed by the U.S. District Court for the Western District of Tennessee. Lastly, this court should consider appointing an independent and disinterested attorney to represent Jason Autry to ensure that he intelligently understands any decision to waive attorney-client privilege with his trial counsel. So wherefore, the state respectfully requests that this honorable court deny Adams' motion to conduct an in-person hearing with Autry. And furthermore, the state requests that Jason Autry be appointed an independent and disinterested attorney to ensure that he intelligently understands any decision to waive attorney-client privilege with his counsel. So there you go. They've got, they just put the cover sheet attached to show that he's got this pending. Let's see. Yes, and there's a bunch of like Aryan Brotherhood stuff going on with Jason Autry. He's got the tattoos. And I'm not well versed on, Brotherhood versus Aryan Nation, or really where they are not like highly present in different facilities. But yeah, he's got those tattoos. All right, then we've got a response. So the state was filing a bunch of stuff on December 2nd. All right, so this was response in partial opposition to Petitioner Adams' motion to file the second amended petition for post-conviction relief. So the longer document that they were reading, the state's saying, hey, in general terms, we're not opposed to Adams filing a second amended petitioner for post-conviction relief. Petitioner Adams' first amended petition, filed on January 22nd, 2024, did not contain a signed certification of counsel required under the Rule 28, Section 6 of the Supreme Court of Tennessee Rules of Post-Conviction Procedure. If Petitioner Adams' counsel now presently believes that the second amended petition has raised all non-frivolous grounds, constitutional grounds by existing law, or a good faith, do we use commas? Or a good faith argument for the extension, modification, or reversal of existing law for appropriate post-conviction relief, the state has no objection. However, the state of Tennessee does object to Petitioner Adams raising any quorum nobis claims in his second amended petition for post-conviction relief. The state objects to the following claims on this basis and asks the court to strike same from the second amended petition. He mentioned quorum nobis, like, hey, we raised this in previous motions, but it was just a parenthetical. It says, furthermore, the state of Tennessee objects to all claims set forth in the second amended petition that Petitioner Adams could have presented for determination at the trial or at direct appeal and failed to do so. These claims are deemed waived for purpose of post-conviction relief. The state objects to the following claims on this basis and asks the court to strike the same from the second amended petition. It's interesting that they're just blocking paragraphs. Meanwhile, the way Doug constructed the paragraphs in his filing was like, hey, there's this issue. They weren't able to present it at trial. And we also want to maintain our objection that if you find it was available, that we also want to raise it as an ineffective assistance of counsel issue. And that would all be within the same paragraph. So seems like blind striking here. And that's Amy Wyrick. And then they had another response here for the subpoenas for the lawyers and the Zoom depositions. So they say, although the rules do allow for deposition testimony to be admitted in a post-conviction proceeding, it is under very limited circumstances. Post-conviction depositions seem to be for the benefit of petitioners who are incarcerated in other states. If petitioner is incarcerated out of the state, petitioner shall be allowed to offer testimony by affidavit or deposition. The prisoner shall appear and give testimony at the evidentiary hearing if the petition raises substantial questions of fact as to events in which the petitioner participated, unless the petitioner is incarcerated out of state, in which case the trial judge may permit the introduction of an affidavit or deposition of the petitioner and shall permit the state adequate time to file any affidavits or depositions in response the state may wish. The taking of witness depositions is also apparently authorized in post-conviction proceedings, but the taking of a deposition must be warranted by exceptional circumstances. The party requesting court approval has the burden of showing that a deposition is necessary. The party must establish that due to exceptional circumstances, it is in the interest of justice that the testimony of a prospective witness be preserved. Where the allegations of absence are conclusory in nature with no factual elaboration, the courts may deny the motion. In this light, a deposition may not be allowed where the witness's testimony is immaterial or otherwise irrelevant to the trial. Petitioner Adams has not demonstrated any exceptional circumstances or shown that it is the interest of justice for this court to permit depositions of Michael Scholl, Michael Flanagan, and ADA Paul Hagerman. So it looks like they're not, let's see, based on the foregoing, the state respectfully requests that this honorable court deny Petitioner Adams' request to schedule depositions or to allow Zooms. So they're not really responding to the subpoena for materials and responsive documents. They're just responding to the request for deposition. There was an order to unseal some filings on the 4th. I don't know if it'll say anything interesting. Usually probably open and close the record so they can access something. The parties agreed in open court that counsel for petitioner would review the documents first to determine if they were relevant to the post-conviction proceedings. If relevant, a copy would be provided to both the state and petitioner. The court orally ordered the clerk to allow access to the sealed files to petitioner's counsel, Attorney Bates, and to reseal the documents immediately after they were reviewed and any necessary copies made. So this is because they're all in the possession of the court clerk and or court reporter. So you guys might remember, I think during the YSL trial, the exhibits had to be, the custody of the exhibits that the court reporter was keeping, they had to transfer it to the new staff when we had a switch of judges and staff. And then this order is just to memorialize that order, that unsealed to reseal. And then an order for appellate court records. So is this Bradbury? Yep. So Bradbury is basically saying, we know that there was a court of appeals proceeding, and because there's these proceedings now in my court, I want permission for the circuit court clerk of Hardin County to be able to obtain the records from the Court of Criminal Appeals, from the appellate record. So we need our exhibits back. We've got, and then in order to continue, if these are short, we can get through all of the December ones. We'll keep going. Order to continue. All right, so the court sua sponte, so on their own, determined that additional time is necessary for the parties to adequately review the voluminous discovery and prepare for the evidentiary hearing. So this is a schedule now. They're going to do, the petitioner has to file his amended petition by December 18th, 2024. Just because remember, they used to have the scheduling order. So the state shall file any responsive pleadings by January 3rd, 2025. Petitioner shall file, if appropriate, any rebuttal pleadings by January 10th, and then the court will conduct a hearing on any pending matters on January 16th, 2025. If no matters are pending, no hearing will be held. Then they have these blocked off. A motion, petitioner's motion relative to the testimony of Jason Autry. They're blocking that for March 18th. And then, should the parties request other matters be heard on March 18th, the deadline for filing any of those motions will be March 7th. And then they've got evidentiary hearing shall be continued from May 13th to May 19th. And you guys know that's when we started watching some of the snippets, some of the testimony. They say the matter is anticipated to last 5 days. We've got a million open tabs. All right, discovery response. So this is the state's discovery response in the reference case. If other discoverable information becomes available, it will be provided. I bet there's no ATM video or device on this. And then the state's demand for notice and reciprocal discovery is found below. So their line item list, they say all materials contained in State of Tennessee versus Zachary, Rye Adams case file, previously made available to Douglas Bates by ADA Jennifer Nichols. So they're sending it again. All materials obtained from Tennessee Administrative Office of the Courts by subpoena related to billing records for Jennifer Thompson, Jim Simeons, and Jerry Gonzalez, previously made available to Douglas Bates by ADA Jennifer Nichols. And then Tennessee Comptroller, comprehensive report on Jennifer Thompson's Administrative Office of the Courts billing records related to all work performed and billed for this case, the Zach Adams case. And I think that's going to be a whopping document. So I forgot that was December. So we might not look at that today. And then witnesses. So the state's witnesses at this time, remember, they plan to call 6. They have a boat guy that they want to call. But back in December of 2024, these are the witnesses they identified to Doug Bates. So Jennifer Thompson, Brett Booth. Did they spell it Brett? Oh my God, Brett Booth is now Brett Booth on paper. Oh my God, that's so funny. They really spelled his name as Brett. That is gold. Jim Simmons, Mitchell Hayes, Jerry Gonzalez, Jennifer S. Nichols, Kathy Ferguson, and Forrest Richardson. So I think that's who puts together all the billing. I'm not sure I know who Mitchell Hayes is. Brett Booth is crazy. Brett Booth is crazy. For anyone that doesn't know why that is hilarious, there is some guy, like a citizen out there that does tactical search and rescue work that, what's his name? Tony Calabrese. He spoke with the news outlets and he was saying, hey, Jeff Jackson and Brett Booth, they busted into my property without a search warrant and they were like beating me up. And his girlfriend at the time was like, it was horrible what they were doing to him. And because Tony was saying Brett Booth and not Brent Booth, TBI issued a statement like to the media addressing the issue and was like, we don't know what Tony Calabrese is talking about. We don't have a Brett Booth that works for us because his name is actually Brent. But here they are spelling it as Brett, and that's just very funny to me. And then they have their notice here. They want reciprocal discovery from the defense. So, yeah, the next one is the very long document. So, and I think it's going to be worth going through. So this is all the comptroller's analysis on the breakdown of Jennifer Thompson's billable hours, like the categories of what she spent her time working on, and copies of the authorization. But all the way down here, we have like 300 pages of line item things. And I think some of them are going to be interesting, especially since they're in chronological order. So... oh, Mitchell Hayes is the boat guy? Oh, chat. Mitchell Hayes is the boat guy. So Mitchell Hayes is a random guy who comes from a law enforcement family who is now, of course, color me shocked. saying 14 years later that he was out boating and heard the shot Jason claimed to have happened under the bridge. So yeah, there's a lot here. This is obviously a longer stream, a longer piece of content, and we might take this out of order. Maybe we'll get through all the filings, and because I want to make sure we are ready to go on Monday. The hearing's going to be on Monday, you guys. So I want to get through the filings and trial and error. The transcript thing, I created an account and now I can't look at any of the transcripts on the site. And if you guys are closing them off for a reason, that's fine. But if that's a mistake, I would love to be able to like look through some of the sidebar transcripts and the jury charge conference transcripts before the 29th. And then on the 28th, guys, I want to rewatch the opening statements from these proceedings. So just to see, I want to see if there's like a difference. I feel like it's going to be easier for me to follow Doug with his magnet board. There's just so much more for us to pick up on, right, of what Doug's trying to put down now that we have the backing context. So if time allows, we'll look at this very long billable hours thing. And we've got, oh, and DV says, I was looking at his online footprint and I guess he knows some Frizels. Yeah, very interesting, very interesting. Ah, and thank you, Trial and Error Podcast. Should be up today or tomorrow. Amazing. And no rush. It's like the holidays, but I think some of those sidebars are, I mean, we've saw the Kay Riggs pulled the snapshot of Jennifer Nichols being concerned about being called a giant snake and how Jason Autry says she's going to have a case flip on her, be overturned because she was forging documents. I want to see it all. So I love the sidebars. Yeah, so the state gets to add new evidence. I guess the argument would be it's a rebuttal to, in a way, it rebuts the claim. I don't know. Yeah, they'll say it's not new. It was in a file 10 folders long with the wrong file name. So, yes, DB has also been making this mess into a long ass spreadsheet. What was the flat ass facts with the Victor Dinsmore recording? I'm telling you the flat ass facts. Oh, I love phrases that come out of these trials. So let's finish the December. We have a quick notice of filing that the amended petition is coming in, and then we have the formal filing of the amended petition, and it's about the same page length. So I should have just gone to this one and read this in case there's any changes, cleaned up for grammar, who knows. I wouldn't imagine that there's any substantive changes. Like, we have the same sections outlined here. So in any case, I should have just read this one. It would have been cleaned up, maybe. I'm sure the table's still in here. Yeah. So I think we probably got the gist of it. But just so you guys know, it was formally filed on December 12th, 2024. So, and then we'll start next time we get together for a stream, you guys. Which maybe tomorrow. I don't think I'm gonna do tomorrow. If I do tomorrow, it might just be something stupid just to hang out with you guys. But we'll get together and we'll watch Jennifer Nichols' The Scrooge, the Grinch movie, for a holiday watch party tomorrow. But that would mean Friday, right? Friday, tomorrow's Thursday, Friday. Friday we'd be picking up with starting with the state's motion to dismiss these post-conviction claims. So we've got a lot to get through. There were two things that were linked on the media page that I couldn't open and download. They were giving errors. So one of them was an order denying petitioner's sealed motion to unseal statements of Michael Scholl. And the other was Exhibit A to Jason Autry motion, which we'll see more what that means in context, I guess. But yeah, so I dropped the link earlier to the folder with these downloads. I'll drop them in the chat again, and they will be in the description because they pulled down that media page early. So that's in the chat. Yeah, DB, are you talking about the billable hour, the line items? Oh my God, I have so many tabs open. Maybe I closed that one. Yeah, incredible timeline source. In all seriousness, like, I jumped around last night. I saw it right before I went on with Miss Janet Demeanor, so I didn't have time to just sit for hours. But I was like looking at, that's how I was aware of the time period when they were arguing to be able to add Luke Evans to the team. Like, so much time was focused on that. Interesting details. There was a detail about the nail polish, and I wish I could search it. But we go and apparently speak with somebody to talk about this nail polish. That isn't the same nail polish. It's just nail polish that's a similar color. But yeah, incredible timeline here because everything is down to the date. You can see when she's traveling to go speak with witnesses, when she's speaking with prosecutors about, and you know, it's not like spelling out everything, you know, there's still work product you're not going to put in a line item. But yeah, call to Maddox, call to Cindy Adams, call to, you know, when did Jerry Gonzalez really come into the picture? It looked like March of 2017. So really cool stuff here. So we'll try to fit that in. I don't think we'll do it in order, but maybe when we get through all the rest of the documents, we'll go through that. So, and DB, you do incredible work. So shout out to DB in the chat. With that being said, you guys, Merry Christmas to everybody. Happy holidays. Happy Wednesday. Looking forward to eating some good food. Hope everyone gets to do the same, gets to spend time, or at least speak with, reach out to the people you care about. Thanks for spending the morning of your Christmas Eve over here. Looking forward to see what this case holds. Again, we'll be doing whatever content, deep diving until the hearings, and we will be live for the hearings. So Monday and Tuesday, like, I'm not kidding, those are probably going to be like 10-12 hour streams. So be ready. Be ready for it. And my thought is new year, new trial. I want to see a new trial here. So again, with bottom of my heart, I hope everybody has a great rest of your day, great holiday. See you guys whenever we get together again. Please take care. Shout out to DB. Heck yeah, shout out to DB. And just everyone have a good one. Hope to see you guys around somewhere in these YouTube streets the rest of the day. Merry Christmas, Gigi. Charlie's like, no, I still have real work to do. I hope the rest of your workday is easy. I hope you get to leave early and avoid traffic. Shout out, you know, anyone that's still stuck doing their shopping. Wishing you well. Wishing you well. Be nice to the retail workers. And again, oh, Bailey's, you're so close to it being Christmas, right? You've got like what? You've got like 6 hours till it's Christmas, something like that? 7 hours? So O'Bailey's gets to have Christmas before me. Being in a different time zone. Merry Christmas to you, O'Bailey's. Maybe when I go to the store today, I'll pick up some O'Bailey's. Everyone, just have a great, great one. Thank you again so much for spending your time with me today, and see you guys soon.